Good morning, everyone. This hearing is in the matter of case number CFI 034-2022 before Justice Lord Angus Glennie. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of the hearing will be issued by the registry on the judge's instructions. The claimant is represented by Stevenson Harwood, Middle East LLP. Lead counsel is Ms. Caroline Hibbard. The defendant is represented by Baker Tilly Law Corporation for Legal Consultancy. Lead counsel is P.V. Shaheen. Thank you.
Thank you. Yes, well, there have been no pre-trial checklists issued in this, lodged in this case. Can either of you explain what the position is?
Yeah, thank you. We informally applied for this pre-trial review to be adjourned, and we're asking for the hearing date to be vacated and adjourned to September. And the parties have a preliminary agreement on this position, but we haven't had the chance to submit our application in advance of today.
Why not?
Various
You say you haven't had the
relating.
chance. You say you haven't had the chance. You could have lodged a motion anytime.
We were reaching an agreement and tried to file a consent order, and the position.
The matter of the trial date is not a matter for the parties simply to consent. It requires an application to the court.
Yeah,
because the court has other considerations to take account of in addition to the parties' convenience.
No, we understand, and that's right. And we just it's purely a basis of getting instructions, getting everything finalized to make the application. We were trying to get it done before today, but we didn't quite manage. But nonetheless, I don't want to waste the court's time at all, but we're not really ready for the pre-trial review today, and we're not. So it would be best if everything was adjourned and deferred to a later date.
Well, if the case is going ahead in July, we need the pre-trial review now.
The parties have agreed to adjourn the hearing.
Parties can't agree to adjourn a hearing without the court permission.
No, understood. The parties have agreed to seek the court's permission to adjourn it.
To adjourn the trial itself?
Yeah.
Or the pre-trial review?
Both.
I think you're muted.
Sorry, I think the connection might be a bit unstable, but I said both.
Right. What's the reason for wanting to adjourn the trial?
The reason is the delay in the expert process. The expert reports were due to be submitted this month, but there have been delays on the defendant's side in providing original comparison documents. We're doing a forensic handwriting expert process, and we need the originals from the defendant, which were requested during the disclosure process. We need those for the expert process. We haven't received or arranged a date for that yet. And now that we have nearly reached an agreement on that process, our expert needs the time to look at the documents and conduct her examination.
How many documents are we talking about?
Our expert requires between around 20 originals to compare against the guarantees, which are the subject of the dispute.
Yep. And you've now reached an agreement that 20 or so will be given to you. Is that right?
Yes.
And when will they be given? Do you
know? That's a question for the defendant, really, but we have reached a provisional.
What have you agreed?
We had agreed that they could be made available within days, but we then needed to confirm with our expert when she was available. It's a bit of a chicken and egg scenario that we were waiting for the defendant to confirm what would be available, and then we needed to check with our expert when she was available after that.
Right. Well, and what have you found out, having checked?
She can do it with a 4-week timeline, so she can't do it in the next couple of weeks, as was provisionally agreed. She's a very in-demand forensic expert.
Right. So you're saying there's no way you can be ready for trial? in July?
No, we have tried to make it work. We've done everything we can. As the claimant, we're eager to press ahead, but we also know that the forensic expert process is probably the most important piece of the puzzle here. So we want to get that done before we go to trial in the best way possible.
Right. Mr. Shaheen, what's your position on this?
Your Lordship, that order passed by the Honorable Court on 16th May 2024, it said the expert's report shall be filed and served by no later than 11th June, and supplemental expert report shall be filed and served by no later than 21st June. So by that order itself, which came much later to the case management order, I think a trial starting on 8th July will be practically not possible because it's coming very close to that. The exchange of expert report itself. And still there are document exchange process which is going on. The expert reports are not yet submitted. We have not submitted, the claimant has not submitted a pre-trial checklist also here. So I think it's not prudent to have that pre-trial review today. And the case may have to.
Mr. Shaheen, there's two stages. If the trial goes ahead in the July date, we need the pre-trial review now.
Practically, Your Lordship, what happened is on 16th May 2024, that order has changed the scenario substantially. That is why we agreed with the claimant's counsel. If they are requesting for postponing the hearing, we will cooperate with them and request the Honorable Court to consider.
Yes, but there's been no formal application to adjourn the hearing.
No. Claimant did not submit a formal application, neither have us. We have not submitted a formal application. That's true.
So what date are you both looking for a trial?
24th of September, 3 days listing.
Does the court have 3 days availability then?
Unconfirmed. We asked the registry, but they haven't been able to confirm yet.
So what date was it?
24th, 25th, and 26th of September.
Right. And is that the day you're working towards, Mr. Shaheen?
Yes, we agree with those dates. We don't have a problem. We have consented.
Right. What I'm going to do is I'm going to, Hayley.
Yes, Justice Glennie.
Can we have a word separately from this, either on screen or on the phone? If I adjourn for 20 minutes, we can then have a word.
Of course, perhaps can I invite the parties to disconnect from the call?
Yeah.
That's fine. If you do that, then we can speak. And if you can be back at, it's now 12:18, I think. If we come back at 12:40.
Yes.
Yeah.
Yes.
All right. Thank you.
Thank you.
Now, Mr. Shaheen, Ms. Hibbert, I'm concerned about this because in the email correspondence with the registry on the 13th of May, which involved a consent order about the expert reports and changing the dates for the expert reports. The registry was told in clear terms that passing that consent order would not impact the trial date. Do you understand? Why was that said when it wasn't in fact true?
It was understood to be true at the time. That the position of the claimant is we thought that was going to be possible, but that really depended on our expert being able to do her report very quickly, which in the event not going to be possible, and it was also down to when we could receive the documents from the defendant, and we've been seeking disclosure for over a month now, and we have finally reached a position where we know what we will receive, but it's taken a long time.
It's very important when you're communicating with the registry or the court generally that correct information is given, and if you don't know, or if you think something may be the case or may not be the case, or you don't know, you should say so rather than give a categorical assurance that the proposed steps will not impact the trial date.
At the time, we did think we were.
Thinking is not good enough if you don't take steps to be clear about it. If there's any uncertainty, it should be told to the registry at the time.
Understood. We were trying to make it work at the time, and it comes down to a number of things that haven't worked out.
Very well. What I'm going to do is this. I'm going to adjourn this pre-trial review. And you want, I think both of you want new trial dates fixed. And you told me that 24th, 25th and 26th September work for both of you, I think. The court can't do that. The court can't do those dates precisely, but it could do the 23rd, 25th and 26th. That would be the Monday, Wednesday and Friday, but not the Tuesday.
Right. Check the
Thursday would it be? So 23rd, 24th and 20.
No, 23rd, 25th and 26th. In other words, it's the
Right.
You can't do the Tuesday 24th, but can do the Monday 23rd instead.
Okay.
Does that work?
Yes, Your Lordship.
Yes.
Right. And we could, on that basis, resume the pre-trial review on the 22nd July. Does that work? It's a little bit more than 6 weeks. More than 8 weeks.
The 2nd of July, did you say?
22nd.
22nd.
It's a Monday.
It's Monday. That works, Your Lordship.
Sorry?
My concern is that we've provisionally agreed to do the supplemental expert reports after that time. And it would be better if the expert process was finalised before we do the PTR.
When have you, what date have you got for the expert?
28th of August, I think, for the supplemental.
That's only a month before the revised trial date.
Oh, 14th of August. Apologies. 14th of August.
Okay. What about the pre-trial review on the following day, the 15th?
Yes.
Mr. Shaheen, would that work for you?
Is it 15th of August, Your Lordship?
15th of August.
Yes, because it has to be between 8 to 4 weeks according to the rules.
Yes, that's indicative guide. But I think 15th August is about 5 weeks before the trial date.
That works.
Haley, can we do 15th August?
Yes, that can be accommodated.
Right. Well, what I'm going to do is make an order in these terms, that you will, one or other of you will file with the registry by 4 p.m. tomorrow a motion seeking to change the date to adjourn the PTR until 15th of August. Sorry, 15th of August.
Yes, Your Lordship.
And to adjourn the trial, to refix the trial dates of 23rd, 25th and 26th of September.
23rd, 25th and 26th.
If that is filed, if that motion is filed by 4 p.m. tomorrow, and this is a strict deadline, I don't want anyone saying they didn't understand it, by 4 p.m. tomorrow, then an order will probably be granted in those terms, with those dates. If it is not, lodged by then, filed by then, the motion will be refused, and we just continue with the trial date, come what may. Do you understand?
Okay. That's understood. Thank you.
Mr. Shaheen, you understand that too?
Yes, Your Lordship, we'll cooperate.
Thank you very much. And I don't think, therefore, there's anything further to do at this stage, apart from adjourn this pre-trial review until the date to be fixed by the subsequent order. Haley, does anything else need doing?
I think that's everything addressed, Justice Glennie. Thank you.
Thank you very much. Thank you, both of you.
Thank you.
One clarification, Your Lordship,
Yes,
regarding submission of the expert report.
yes.
Are we postponing the date to July? Because we had kept it initially in June. And the request from the claimant, which we supported, in fact, subject to court's convenience, to push it to 28 July.
What
Date
date in July?
The deadline for submission of the expert report and then followed by the deadline for supplemental expert reports. The suggestion from the claimant side, which was approved by the defendant also, was 28 July and 14th August. So if we can mention that also in the request to the Honorable Court, we will do that.
Is that agreed, Ms. Hibbert?
Yes.
Right. Well, I think if that can be included in the motion filed by tomorrow, 4 o'clock, and Haley, on that basis, I'll be minded to grant that if it's part of that motion.
Noted.
Yes, Your Honor.
Right. Well, thank you very much.
Thank you very much.
Thank you.
You.